Sir James, the board would like to hear you on one matter, and that is the appropriate judicial review test, traditional judicial review grounds or correctness. I think you've kept your powder dry in your case by keeping each option open, but we would like to hear your submissions on that.
Certainly. On that alone, my lord? Or?
On that alone.
On that alone. My lord, we're going to start with that. Having kept the powder dry. It is, of course, an issue of statutory interpretation, and the question is whether the intention of the framers of the Freedom of Information Act was either to provide for a reviewing jurisdiction in the court, with decisions by public authorities in effect reviewed on judicial review grounds, but with the usual respect to the primacy of decision-making by public authorities, or to set up a system, in effect equivalent to the tribunal system that one has under the UK Freedom of Information Act, of appeal or reconsideration, in which the function of the court is different. It is to consider, on that conception of FOIA, the factors and weigh them itself as the primary decision maker. And we recognise, which may be why we've kept our powder dry, as my lord very politely put it in our case, that is not, we respectfully submit, necessarily a straightforward issue in terms of interpreting this piece of legislation. We do start, however, just before coming to that issue, we start by inviting the court to recognise that the argument in favour of the court adopting a correctness approach for itself was never mounted by this appellant below. The argument that was mounted by this appellant below was simply that NGC had not in fact done the balancing exercise under section 35. It was not suggested that the courts below should conduct the exercise for themselves, whether as a fallback argument or at all. Indeed, just to give you one reference in relation to this, if you go to the Court of Appeal's judgment below at paragraph 7, and that's on page 847 if you have it electronically, but if you have it loose, page 847, paragraph 7, you will see that the appellant's submission to the Court of Appeal involved a criticism of the trial judge, see Roman 3, for having herself impermissibly conducted a section 35 balancing exercise. And that reflects exactly what was said in the appellant's submissions to the Court of Appeal, which you have recorded at page 672 in the electronic bundle if you need that. You'll also recall, just by way of putting this issue into context, that the Court of Appeal in this case did consider the balance in the alternative for themselves. It's not entirely clear on what basis they undertook that exercise, but they undertook it certainly on the alternative basis that there had been public law error. So it may be that they were considering that as part of the question whether or not the matter should be remitted if, contrary to their primary conclusion, there had been public law error. And you see that summarised in their judgment at paragraph 13. But then there's a detailed section later on in the judgment, as you'll recall, where they effectively do the balance for themselves. So the submission would have been that even if you were to conclude that correctness is the right approach for the court to adopt in these cases, first instance, and then the appellate court does its appellate function, if that is the right approach, correctness, we would nevertheless have submitted, for reasons that I won't go into because you want me to focus on this particular issue, but we would have submitted that that had been done by the Court of Appeal, the majority, for themselves anyway, and they had reached the very, very clear conclusion that the balance was, as they put it, clearly against disclosure. And you have that in particular in the Court of Appeal's judgment from round about 110, paragraph 110 onwards, where they list for themselves the factors in favour of disclosure. Then they consider what they described as the chilling detail of the consequences were disclosure to be given in terms of all of the impacts on the economy of Trinidad and Tobago and so on. But I just give you that by way of introduction to the issue you've asked me to address. Our submission is that under this legislation, the right interpretation of it, recognising that the other one is at the very least arguable or tenable, but the right interpretation of this legislation is the judicial review approach. And we make that submission because essentially the legislation is set up on the basis of considerable and express in various places respect to the primacy of the decision-making function of the decision-maker. You have the points, I'm very well aware, that both of which I think were made by my Lord Sales relating to section 22, specifying the various people who could be decision takers for the various public authorities who might be making these decisions. That provision in the Act, section 22, is not, with the great respect to Mr. Ramlogan, a fallback provision. It is a provision which specifies who, as the primary decision maker, are the individuals who can actually make a valid decision for the purpose of this Act. And the significance of section 22 is that it emphasises that they are contemplated as the primary decision makers. You can get the same point, perhaps with almost more force, in section 38, capital A, paragraph 2, the provision which relates to the Ombudsman, and the force of that provision is that if a complaint is made to the Ombudsman, what the Ombudsman can do is to, in effect, to make recommendations which then go back to the public authority. The public authority is not bound by the decision of the Ombudsman, but needs to take them into account and make a fresh decision if appropriate.
I think you mean section 38A3.
A3, my lord, I'm so sorry. Have I got the right one? Yes. 38 capital A3. So that is that. But perhaps the key, or a key provision in this Act is section 39. Section 39 is on page
1089.
1089. Thank you. And one starts perhaps with for the removal of doubt in 39.1. And we submit that what for the removal of doubt suggests is that the person aggrieved by a decision not to disclose documentation or information by the public authority, what the person aggrieved can do is that which could always have been done in relation to a decision by a public authority, namely to challenge it on public law grounds in judicial review. So the for removal of doubt is at least of some significance by way of introduction, because it suggests the existence and operation of a usual jurisdiction. And all they're doing is removing doubt just in case anyone thought they were doing something different. But then a person aggrieved by the decision of a public authority under this Act may apply to the High Court for judicial review of that decision. And again, perhaps the significance of that wording is not merely that it refers to judicial review as an idea. In other words, you're doing something which is traditionally associated with the primacy of decision makers and the court performing a reviewing function rather than a de novo jurisdiction, but lies in the contrast of what the draftsman would have done if the intention was simply to refer complaints, if you will, or aggrieved people to the High Court to exercise a de novo jurisdiction. Now, we don't have to look very far to see what that sort of legislative provision looks like, because that's the sort of legislative provision we've got in our own Freedom of Information Act in the United Kingdom. And what Parliament does, if that's what they choose to do, what the legislature does, is to make it absolutely clear that they are setting up a route of appeal, if you will, but a route under which the person aggrieved can invite the court to exercise the judgment afresh. They set it up and make it absolutely clear that that's what they're doing. So this sort of provision stands in contrast to the Freedom of Information Act in the United Kingdom.
Do we happen to know whether the Trinidad and Tobago Freedom of Information Act was modelled on the UK Act?
My Lord, we don't. But it appears unlikely that it was modelled in that way, if I can put it that way, because the structure of very similar looking ideas is very different. Right. I rather suspect that it was modelled on the Canadian, equivalent Canadian legislation, but it's not entirely clear. But it seems unlikely that it was modelled on the UK one. I refer to the UK one simply to make the point that there is, as the draftsman in Trinidad and Tobago would well have recognised, an obvious way of setting up a de novo jurisdiction if that's your intention. And indeed, it might be thought the point is even more powerful here, because if you're going to be referring to a traditional judicial review function, and yet what you're trying to do subliminally is to say, by the way, the court can exercise a de novo jurisdiction, it's a doubly odd way of doing it, because you set out to confuse, if that's truly the intention. You refer to judicial review, and then you have, through some back route, to try to reinvent the wheel and get de novo jurisdiction in. I'm reminded that the Trinidad Act is 1999 and ours was 2000.
Right.
Which
okay,
might have been the shorter route to the same answer. So, my Lord, those are the key features we submit of Section 39. For removal of doubt suggests an ordinary jurisdiction. Judicial review suggests that that is the jurisdiction that was intended. And if they wanted to do de novo, they would have done something different or clearer to avoid the confusion that would otherwise necessarily follow. Now, of course, there are the alternative arguments you'll be very well aware of. The alternative argument we, I hope, helpfully sought to set out in our case so you could see it, as it were. The alternative argument is, in essence, that this is set up so as to create a statutory duty, and the argument would therefore be that if you look at the Judicial Review Act in Trinidad and Tobago, the relevant parts of which were cited in my Lord Sales's judgment in the earlier Maharaj case. Remember, there was a citation there of Section 5 of the Judicial Review Act, which set out the various grounds of judicial review, and they included policing whether or not there had been a breach of statutory duty. And the argument would have to be, well, because it's a statutory duty and the court can police a statutory duty, that means that you can and should, as a court, look at it and make your own mind up. But I respectfully submit that although we recognise that argument existing, the stronger one, the greater indications, are in relation to the alternative position, and that is the position that we respectfully invite the court to take. I mean, the one thing to say finally in relation to these arguments is that there is, with respect to the jurisprudence in Trinidad and Tobago, at least a degree of confusion about precisely what the right approach is or should be. The courts have, I think my Lord Sales pointed out in your earlier Maharaj judgment, the courts have in that jurisdiction on occasion, and some of them suggested that this is a jurisdiction under which the court can, in certain circumstances, get stuck into the issue for itself. In other words, as a de novo matter. But even in relation to those suggestions, they have quite often been preconditioned by what looks like a supposition that there had been earlier error of public law. In other words, there had been a failure to consider something, including in particular Section 35. There had been a total failure to consider that. Therefore, the court's jurisdictional door was open to do it for itself. And to some extent...
I think it was suggested in one of the cases, it was a customary case, that there was an intermediate position
hybrid position.
Hybrid
Lord
position,
Sales described.
referred to in my Lord's judgment.
Yeah, which would be, but that would, we respectfully submit, be a very odd interpretation. To some extent, one sees a little bit of that approach in the Court of Appeal's judgment in this case, because it's not entirely clear on what basis the majority were undertaking the exercise that they then undertook at paragraph 110 and following. It's absolutely clear that what they were doing there was to consider the matter for themselves. But they were not doing that on the basis that the Act required them to adopt that approach. They certainly weren't doing that. They appear to have been doing it on the basis that they were wrong about their primary conclusion, that there had not been a public law error, if that is negatives in one sentence. So they appear to have been approaching that on the basis that if there had been public law error, we'd have been looking at this for ourselves for various reasons. And one can only think that they were thinking they were going to do that because if there had been public law error, they needed to think about remittal. And sometimes the question is whether the court decides that for itself. But as you know, in this jurisdiction, the court would be very, very reluctant to go down that road because there would be constitutional implications in terms of separation of powers and who should actually be making the decision. And normally in a judicial review case in this jurisdiction, the court would only start taking that decision for itself, leave aside human rights considerations, would only be doing that if there was only one possible answer to the question. And then it would step in and give that answer. But this feels unpromising territory on that front. So there is, we respectfully submit, a degree of confusion in the case law in the courts of Trinidad, but I do submit, if necessary, that this can on no view be a hybrid approach. The true choice is the one I mentioned. Is it a JR approach or is it a de novo approach?
Can I just check one point on the law of Trinidad and Tobago? You say the courts in England and Wales would generally only go down a route of specifying the answer if there's only one possible answer, which I think there was a footnote referring to the Simplex case, which one knows about. That position has been moderated by statutes.
In section 31A.
Yeah. 31. I just wanted to check, is there isn't a section 31A equivalent in Trinidad and Tobago that I'm aware of?
I don't know the answer to that.
All right. Perhaps I could ask if that could
we can certainly check and see
how it does fit together. It would be useful to know.
I mean, my Lord, I had that in mind. I had that no material difference set of arguments in mind. But I also had in mind the situation where, for example, there's a substantive challenge based on irrationality. Almost invariably, the court would remit that back to be reconsidered because there wasn't a justification for it, but there might be if they thought again. But in that situation, if they conclude that there could be only one rational,
absolutely, that's
then they
what I really meant by simplex.
Yes, yeah, that's a slightly different question from the simplex one, but we'll certainly check and see whether there's anything in Trinidad equivalent to section 31(2)A, I think, of the senior.
Yes, right. That's really what I was asking. Thank you.
My Lords, that's all I wanted to say about the issue of interpretation. Yes. Light of the Court Board's indication, I won't address you on other issues unless it would help.
Sir James, thank you very much.
Very good.
Mr. Ram-Logan, is there anything that you'd like to add on the question of the approach, i.e. the correctness approach as distinct from the judicial review approach?
But I had agreed to allow my junior, Ms. Blackstock, to deal with the reply. I don't know that there's, I don't know, I'm trying to communicate to see if she wishes to say anything, but I see yes, the podium's there. Well, I'll defer to her.
Yes, I will ask her. Is this a matter that you wish to make a submission on, Ms. Blackstock?
Thank you, my lords. No, in terms of any concern you might have about it, and that's obviously dealt with in Petratrin by my Lord Sales, by identifying there that the consideration of it is in the case of Joint Consultative Council. And my Lord sets out the three considerations by the judges there. But essentially, there seemed to be three positions, which was Justice of Appeal Barrow thought that the correctness test, if we're calling it that, would apply on a de novo review. Justice of Appeal Jamadar wasn't entirely clear what the position was, and I think that's where we get this hybrid idea. And Justice of Appeal Noreen said that it would be the responsibility of the court, even in circumstances where there clearly was a Section 35 review undertaken by the public authority, for the court as well to undertake that exercise itself. Now, in the judgment of Justice of Appeal Jamadar, he refers to the constitutional rights and responsibilities of the Freedom of Information Act as providing public exercise in the democratic exercises of the country, to put it. Sorry, haven't got the exact words before me, but it's essentially that. It's that the preamble of the Constitution sets out the participation of the public in the democratic exercises of the country. And you could also look at the fact that freedom of information is encompassed within constitutional fundamental right to freedom of expression and so forth, and therefore draw an analogy, which he appears to do, with those constitutional rights creating a review obligation upon the court. Nevertheless, Section 39 says it's a judicial review, and that's the tension. It hasn't been addressed further as far as we can see in the authorities. It certainly wasn't addressed in this case by any of the parties or by the court, and that's the position that we're left at this point. My Lords, I wanted to just briefly...
And you're content with that position, are you?
Yes, my Lords, we don't push that any further than that. That's the position that exists between the justices there. We don't push for a correctness test, but we can see the value, I suppose, of it in the de novo example, and that's something I wanted to take you to in the time that I have with regard to the reasons analysis in the judgment of Justice Barrow in Joint Consultative Council. This was briefly touched on earlier, but it's quite helpful in my submissions in illustrating what a properly reasoned decision might want to look like. And if I could take my Lords to page 1476. This is the judgment of Justice of Appeal Barrow in the Joint Consultative Council case. There are 3 judgments in this case, each individual, as my Lord Hodge identified. That's why you keep getting the same paragraph numbers coming up, unhelpfully, perhaps. So paragraph 75 illustrates here, no Section 35 override was performed. It thus fell to the court to do so. And the court decided it was appropriate to do so because this case is about legal professional privilege. And that was within the purview of the court, arguably. There will be cases, and such as this one, as we argued below, where it is not appropriate for the court to enter the arena and do that exercise itself because it has neither the expertise nor the skill nor the evidence to do so. It is appropriate to remit to the public authority. So here, it was undertaken. This case, as I say, relied on a document which invoked legal professional privilege. Mr. Martineau, senior counsel below, in that case, in the Court of Appeal, identified 9 reasons why legal professional privilege is important, and they're set out there. If we go on, paragraph 77, those are weighty considerations, but in considering them, I must keep in view that objects of the Act set out in section 3.1, the intention is to make available documents to the public. The about the operations of public authorities and provide a right of access. And if we track through 78, the bottom of the next page, the question is whether the benefits of disclosure outweigh the damage, if any, caused to public interest in this case. Refers back to those 9 factors, apply with considerable force to legal professional privilege between the lawyer and his client, where the advice relates to the personal affairs of the citizen. In this case, we're dealing with legal advice given by public officers in respect of a project in which considerable public funds are to be expended. Issues of accountability and transparency are far more significant. And if I could ask you, my lords, to track through to paragraph 86 on the subsequent page, just for this review of that.
Perhaps just on paragraph 79, one sees the judge reaching his own conclusion on the public interest balance, I think.
Yes.
Then paragraph 86.
Tips in favour of disclosure. And 86, if we track through, my lords, this is no ordinary case in which legal advice has been given to a private citizen. The weighty considerations put forward by Mr. Martinique constitute powerful reasons against disclosure. In this case, the disclosure sought in respect of advice by public officers about a project to be executed on valuable public lands, which is to be financed by a considerable injection of public funds. On the contrary, it's likely to foster greater care in the giving of advice. For the same reason, it is unlikely that candour between ministers or between ministers and legal officers will be adversely affected. So it's showing here the nature of that weighing exercise, which we argue is absent in this case. We also say this is a helpful decision because one of the documents in this case is a legal advice for which privilege was claimed. And I don't have the time to take you through to each of the documents, but you'll recall its request for 1, 4, 8 and 12, which are relevant here. But they have to be looked at in the context of the concerns that were raised by Mr. Maharaj and indeed the broader circumstances of accountability and transparency which the public authority would know about. And perhaps if I illustrate it this way, my lords raised the section 31(1)(b) exemption. That's at page 1082. Perhaps if we go back to that again as an example of this exercise. This was relevant because in interpreting section 31(1)(b), 31 subsection 2d raises whether there are any considerations in the public interest in favour of disclosure which outweigh considerations of competitive disadvantage. And the question was, well, does that do the exercise already? Section 31(1) relates to, as it says in the side note, documents relating to trade secrets. This is about information of the business entity that the public authority is engaging with. In this case, that would be Shell and Shell's competitive disadvantage. And as it says in the reasoning in the decision letter, the pricing, gas pricing and the concerns about Shell's disadvantage, releasing that information would disclose. That's one small document within the context of the concerns being raised. Mr. Maharaj isn't interested in Shell's pricing. He's interested in whether this public authority, and by extension the government of Trinidad and Tobago, in entering this deal, has considered the weighty risks that he identified and the broader risks identified in the news. They are the financial risks to the country, the context of US sanctions, which are now in place, preventing the deal progressing, the finances that would be spent, and in fact are now being spent, and we've referred to this in our case. In 2023, a 30-year license was signed with Venezuela for exploration of gas in this area, for which Trinidad and Shell have to pay $1 million a year, whatever happens. They are paying that money, plus other costs which are not in the public domain. That is financial expenditure in the context of Venezuela's regime that has led to sanctions being imposed. It's a weighty consideration. Likewise, the humanitarian crisis, likewise, the environmental considerations. What Mr. Maharaj is asking for in a reasoned decision is for those things to be looked at in the context of the documents held. If there are parts of those documents which necessarily show confidential, competitive disadvantage issues, they can be redacted. They don't need to be disclosed. But that's not the end of the exercise. And that's why we say reasons are so important, because the public authority is obligated, by nature of being a public authority, to properly consider its duties under this Act. And that is not a blanket reliance on exemptions and a blanket standard phrase, notwithstanding the Section 35 test, which applies in the decision letter. My Lords, I think that's everything I wanted to say, conscious of the time and the fact that this issue has been gone over. Unless I can assist you further, those are the submissions.
Just before you rise, Lord Sales asked a question about...
Mr. Baxlord, thank you. Yes. Sorry, yes, Sir James.
Lord Sales asked a question about whether there was anything equivalent to our 2A. And we think, if this alters, we'll let you know as soon as humanly possible. We think that there is no equivalent in the relevant setup. The key provisions, perhaps, are Section 8 of the Judicial Review Act, which is entitled Remedies, but simply sets out various forms of remedy that can be granted and no equivalent preclusion on granting a remedy if it's very likely the decision would have been the same. In other words, no equivalent provision to Section 31A.
I think Section 8, if I remember right, it ends up with saying such other remedies as the court considers just.
Exactly.
It's open-ended in that regard.
It's open-ended in that regard, so it would bring in, for example, the simplex jurisdiction, which didn't depend upon statute.
Yes.
Statute, as you will recall, altered that case law to modify the test a bit in favour of government, if I'm allowed to put it that way. And the only other provision to bear in mind in the Judicial Review Act in Trinidad is Section 21, which confers the power on the court. It's the court may to remit matters if it quashes them. So again, that would open up perhaps the simplex jurisdiction, but again, if you were going to find the equivalent of Section 31(2)(a), you would find it there. So it would either go in Section 8 by way of amendment or Section 21, and it's in neither place.
Yeah. Sir James, thank you very much. Well, the board is very grateful to counsel for their submissions in this case, and to those who have assisted counsel in the preparation of this appeal. The board will take time to consider their judgment.